Lord, my property has been sold for 8 lakhs. Lord, the decree was for
agreement of sale was how much?
The decree was for about 6 lakh and 93,000 as per interest of 12%, whereas in appeal the interest was reduced to 6%. Lord, it raises an important question of law. Lord, kindly see, my property is worth much more, Lord. That's my case. There is not even compliance of Order 21 Rule 66. The valuation has not been done by the executing court as per Order 21 Rule 66. Lord,
where have you said what is the value of the property according to you?
Lord, when I filed the objections, Lord,
Nominally difference is running at some crore, but it was sold for only lakh.
Lord, I get it.
Is there anything you have to do?
Lord, I have said so in my revision, Lord.
How much for conscience shocks you tell us will do? We tried to see it's nothing like that. You did not put in any value as
Lord, it was 18 lakhs per bigha and it is total land is 20 bigha. Lord, it becomes to more than 1 crore, Lord.
We are not exact.
Lord, the kindly read Order 21 Rule 54 with me. For a moment, Lord. Just for a moment, Lord. For my Lordship, Order 21 Rule 54.
Yours, yes. Sure, sir.
Yes, Lord.
What do you want to do?
I will read Order 21 Rule 54. Where the property is immovable, the attachment shall be made by an order prohibiting the judgment debtor from transferring or charging the property in any way, and all persons from taking any benefit for such transfer or charge. Then Lord 1A says, Order 54 Rule 1A. The order also shall require the judgment debtor to attend the court on a specified date to take notice of the date to be fixed for setting the terms of proclamation of sale. Now, my Lord, we come to Lord page 38. Page 38.
Please read that with Rule 58 clause.
Yes, Lord. Rule 58. And Rule 58, I will apply only if Order 54 is applied with. I can't.
An objection to the attachment has to be raised.
Only if I know that there is attachment.
It was there, sir.
No, madam, that's why I am reading page 38. Page 38. And that's why I was reading page 38. Kindly see. Page 38.
It was entered in.
If the execution is filed on 11th of August, office report C, kindly see page 38. Office report C, it be registered. Warrant of attachment of property be issued. Now, down below order of the same day, the judgment decree order comes. At this stage, copy of Jawabandi for year 99-2000 has been supplied, praying that attachment has already been effected. So the notice under 21 Rule 66. So there is no order 21 Rule 54. There is no proclamation under Order 21 Rule 54. So I had no chance to file objections under 58. There is no compliance with Order 21 Rule 54. And it is mandatory, my Lord. There is direct judgment of this Lord.
All right.
It is mandatory.
But once the Pharmaceutical Council of India has approved it, but there is no scope of any inspection. And that this is fine that the as that although it has been said that this pharmaceutical this procedural judgment, which has said that it is a complete scope.
And so initially that approval was granted. There are three issues, right? One, the Pharmaceutical Council.
Yes.
Is what that, and so far as the affiliation is concerned, what happens?
Now that affiliation, they were not fully stable.
But then
Now,
the approval is also now under question. Then
therefore, the judgment which has taken your time.
I think all of them are going back.
No, I'm just kindly. Can you take this for the 21 volunteers? Can you take? There is one legal case. Let kindly see first paragraph 30. Paragraph 30. Now, having held that the pharmacy act is a special act, dealing with the special subject of pharmacy, the next
What is the stand of Pharmacy Council?
Pharmacy Council, unfortunately, they have not filed any affidavit.
They
signing any affidavit, it has come from the bar. I am showing the I am showing the one letter of partnership comes from
What you're saying is right. 1 minute. Initially, when the pharmacy counsel has given it, was it conditional?
No. No. Well, kindly come to page 205. Page 205 is the approval. Page 205 is the approval. This is 205 is the approval. But just one second. I'm getting to the
What we will do is perhaps that we will restore your writ and ask you to argue. Take that notice. Yes. University. Yes. Have you a problem there?
But one, can I show one letter to you?
You don't need to because you're issuing notice.
By the way. No, returnable will be very short time. I will make it up this service.
Yes. That's what we'll let you know. How would it be? Everything is, how would they go back and then appear in their next day? That's the in addition. Serve on the pharmacy council.
Yes, returnable.
2-3 weeks.
Because I will do it. If it applies to them.
First place, yes, possession.
Status quo. This is position of
Yes. Reverse.
there is some delay or delay of 80.
But here, while denying me an injunction, my lord, both the courts below have failed to consider one very important aspect, and that is, my lord, that the fraud that is being perpetrated on the plaintiff with regard to the title. But on 3rd August of 2012, there is a development agreement entered into, in which a solemn statement is made that the person granting the development rights is the only person who has title. Thereafter, my lord, within 10 days, a suit is filed by his aunt, claiming that she has a title and that the property should be
Family property. Could not have sold it to you.
No, my lord, that's the whole point. He did not tell me. The revenue records don't show the names of anybody else. Please see, my lord, that page 353 of the trial court says. It says so in my favor that I was not told and I was not aware that there were any other joint owners. My lord, please see para 11 of the trial court at page 353.
Your SD performance, there you were not ready and willing.
But ready and willing,
I
tell you,
you
Lord,
didn't have the money to obtain the sanction fees.
Lord, that money has to be paid. Lord, I just explained the money has to be paid after title is paid away. Lord, please see, just see para 11 at page 353. Would your lordship just see that one para the trial court says?
Interim concurrent.
No, my lord, I understand that, but both courts have just not considered this aspect that there is a fraud on me. Please see para 11, my lord.
Succeed in the case.
But in the meantime, there is, would your lordship then protect me to this extent that whatever third-party rights are carried out, Lord, whatever third-party rights, my lord, should be subject to the outcome of the suit.
Without saying.
No, my lord, normally it is the other way around. The court says that there is nothing survives, your suit is infructuous. Please see, my lord, would your lordship just see para 11 at page 353.
Yeah, that's good. It's not a declaration. There's a word of difference. Thank you.
Lord, please see that one paragraph. Your lordship see that.
Thank you.
Lord, then would your lordship at least clarify that the trial court will not be influenced by the observations in the High Court order because there are sweeping observations. Otherwise, my lord, the trial court will may feel bound by it.
Assumption that our trial courts are so ignorant that they don't know what
No, they are not ignorant. But when the High Court or the Supreme Court says something, even
have you ever seen a case where the final judgment they relied on interim appropriate process? Have you ever
they will not rely on it, but your lordship will have a mind what place. sometimes the objects of
The observations made by the High Court are intended only for the interim purpose. They will definitely have no bearing on the final adjudication of case.
obliged. Even if there is a 30-day period. Actually, in this, as a best my case on chief effect, I was terminated without giving me an opportunity of hearing.
I said, no prejudice, sir.
Yeah, actually,
It does not demonstrate that anyone junior to you had been appointed as shikar.
yes, that I said demonstrate. That I said demonstrate.
You couldn't demonstrate it to the
For the High Court, it was there. Page para number 5 of the input order, madam. Please look at the para number 5 of the input order. Actually, why I was saying that? After taking note of the fact that para number 5 of the, para number 7, page 5 of the input order.
High Court said that optional hearing. Hearing was not changed. Optional.
Just actually, what is the, what? In the light of the tribunal's order that is 13/12/1996. That is 13/12/1996, the order says that they have to give preference to the meritors. That the respondent was posted in Saletpur UP school on regular basis by an order dated 28/1997 because I was appointed regular subsequent to the first order. No, I'm not telling. I'm giving the another same post, but in a subsequent interview. That is actually, I'm just telling. But why I'm pursuing this case? I am pursuing this case actually. These schemes are actually, my lord, look into these schemes now. These schemes are very arbitrary and because for the fourth,
has gone for a 6. This 2005 appointment is a completely fresh and shows that appointment letter.
I was actually yes.
2005 appointment letter shows.
2005 appointment letter, actually it is there. 2005 appointment letter. I mean, page 18. Right. I was again put in considerators amount, but actually. Alexa P7.
Where is the 2005 appointment of January 25?
This was the 13/12/2004.
Previous.
For this, I was given an appointment and 4 January.
That was not an indication, not even a word indicates about your previous appointment.
No, that was not. This was a fresh appointment. Yes. Actually, that's the actually Honorable High Court head is saying that I could not have challenged.
Paragraph 13 of the High Court.
My actually, I said demonstrate actually that why my 2000 that was wrong. That is what I'm saying. No, actually, I'm just telling this, madam. Actually, if I go by this appointment, I am not even benefited from the terminal benefits because this is only for 15 years.
They had not given you this appointment.
You have.
Then you would have been completely out of service.
Yes. But this is not compulsory. I again qualified. This is because I again qualified. That is why. But that does not mean that I have worked for 6 years on a regular basis. They could have terminated me without giving me. That's why the report said that. This is a pressure point. But I agree. I am not that issue, my lord. Actually, the report said that I was terminated. That termination is challenged in this petition, which has come to the session.
Your point, but that's not possible. Thank you. We are not.
No, I'm just telling you. I'm just telling actually just I don't take much time. I'm just telling. Initially, I'm just normally I should go into work. In 1992, I was qualified as a Shiksha Karmi. Shiksha Karmi means you are a consolidated.
All that.
No, I can just. I don't take 5 minutes. I won't take 5 minutes. It's less than that. On Shiksha Karmi, I was a monthly salary of 400. And I was regularized in 1996. After my
I was regularized. That regularization was challenged by some people who could not be regularized in the High Court. The High Court said, you look into the merit list. If somebody is qualified, then regularize him. If somebody is not qualified, don't regularize him. So my first regularization was cancelled. Then again in 1997, after the order of the Honorable High Court, they considered me and they issued me another regularization. That is what I am saying. In 1997, they said that in the merit list, I am a qualified candidate.
Question that we asked you.
They did.
Explaining, you doesn't answer that question.
Pirate.
The appointment is a special point.
Yes, that issue I have actually, I agree with that.
Thank you. I said,
I'm just telling it. My 1997 regularization was again actually.
I heard you. How much time? Heard? SLP dismissed. All the next thing. 24.
First, I would point out that after the High Court judgment and in terms of elections, you need a representation. And that was rejected. But despite that problem, he has now retired. He retired in 2015. So it's only a question of notional financial benefits. After his dismissal, on the same set of allegations, which were also pending before the criminal court, he had an honorable acquittal. It was not only by benefit of doubt. Please see that, page 184.
The department should have set aside the High Court of an end to departmental proceeding, madam.
No, Ashish,
Then that is exactly the ratio on which the High Court has
Ashish,
put. You are lucky that the department did not challenge this order.
in fact, they did. They challenged the acquittal order.
We are not talking of the acquittal order, we are talking of the
No,
impugnment.
they haven't. But your Lordships, just
So
see page.
let it rest at that.
Your Lordships have made distinction between an acquittal by giving the benefit of doubt and an honorable acquittal. And here he has not received salary since 2009. He has retired in 2015. He has got no pension, no gratuity, and he has now. Yeah, please hand over one judgment.
2004 itself, that representation was rejected on 16 September 2024.
Yes, your Lordship.
Made unchallenged.
That has been unchallenged. Today he's 65 years of age. Today he's
Virtually like a 32 petition. This is virtually like a.
May I just draw your Lordship's attention to page 184? Just look at the reference ID. Just, I will only read one sentence, 184. Just please, I will not trouble your Lordship with anything more. These are the criminal proceedings, para 52. Please just have one page, your Lordship. In view of the above circumstances, this court has no hesitation to hold that the prosecution utterly failed to prove the case against the accused beyond all reasonable doubt, and the accused are entitled to acquittal under benefit of doubt. Utterly failed to prove.
It is not an honorable.
May I just hand over some judgments your Lordships have
We are
considered?
ordering it's not an honorable acquittal. What will the judge?
There's one more aspect which I request your Lordships to consider. Even if he's now vindicated today, he has retired. It's only a question of financial benefits. He's in penury. He has not received his salary from 2009, 15 years. He has not got his pension. It's only on that, your Lordships.
Thank you. It is dismissed. Next.
Then your Lordships, let this not come in the way of him challenging that rejection.
Withdraw this. You want to withdraw this? You want to withdraw?
Yes.
Self-pity sources withdraw.
Item 25.
Fine.
Very clear, Your Lordships. Two allegations were raised. Page, plus we'll have the petition. Para 9 and 10 are the only two allegations. The allegations that now survive, there's no cause of action surviving her.
Each case has to be done, has to be argued.
No, this-
High Court judgment is not a very well reasoned.
No, but the question is,
Not referred to. 711 position.
so your officer said living in the world, judgment logic follows. The question is, why should the court should then look searchingly at the order 10? That is the language used there. Now, here, can you have take para 9? I can only go to Deborah, para 9 and 10. Page 128, 129. The only issue that seems to survive is that.
सभी दोस्तों
Finally, that FIR, if they do not produce the FIR, that's the only ground.
You know that.
The only ground.
711. Thank you. What is 711?
सुप्रीम कोर्ट में आप लोगों का केस न्याय और अन्याय पे चल रहा है, ठीक है। हार जीत का यहाँ बात नहीं है, बात है कि इसको आज न्याय मिलेगा, ये चीज़ डिपेंड करता है। और सुप्रीम कोर्ट में जो भी चीज़ें होती है सब आंखों देखा हाल होता है, ऐसा तो नहीं है। इसलिए इंतज़ार कीजिए लोग, कुछ घड़ी में अभी 25 से 26 नंबर की सुनवाई शायद चल रही है। इसके बाद बोल रहे हैं हम लोग का जब बारी आएगा तब मालूम चल ही जाएगा क्या हो रहा है क्या नहीं। और सब चीज़ आज सही रहा तो मुझे लग रहा है कि केस फाइनल हो जाए आज। अगर आज फाइनल नहीं होती है तो डेट मिलेगा, और डेट मिलने का कारण भी मालूम चल जाएगा आप लोगों को। ट्वेंटी 26 नंबर अभी चल रहा है रिया रॉय एनएम केस। अभी जो सुनवाई चल रहा है वो 26
Notice has just been issued as to status proof where the petitioners has already been granted. Notice has just been issued as to status proof where the petitioners has already been granted.
Your Lordship will say notice that
They have amended that full writ.
I think it's retrusted. I have much to say in support of the judgment, but the fact remains that notice has just now been issued, and Your Lordship will say notice and interim order in the same terms.
Absolutely, and they all have to be tagged together.
The order is one of the otherwise, I told the court the order has been implemented. They have been pushed to their correct position. Seniority has been altered. Court has said status quo as of today according to it is RS.
Just also clarify that we were continuing.
Yes, nobody is reverted. I had appeared.
कोर्ट नंबर 11 है आप लोगों का, ये कोर्ट नंबर 11 में बहस हो रहा है।
Not an order passed by court 8 is notice and status quo with the petitions. Correct that is. Some matters came here, some matters went.
Which court is this?
Date item 36.
Just now.
Just now.
5 minutes.
5 minutes.
My friend appeared, I appeared. So I have told the court the status quo is meaningless. That whether it is meaningless or not, that's the order by the court. Yes. What's the question? Yes, that's the order.
Same judgment.
Same judgment. Some came here, some came here. Your Lordship may say notice interim order in the same terms. Your Lordship may list this to go to the
Exactly.
We see the justice. Very please take instructions from the petitioner. We are informed that against the this is tomorrow
has been filed.
along with SLP 1106. No, why along with that has already gone. These two will
Yes, no belong.
Has to be.
yes, consistent. How else is the
There has to be.
yes,
We are putting this matter.
yes, this matter will go there. Yes, that's not my statement.
Not necessary.
Necessary then. No, I am not denying that statement. I am saying notice can issue and your Lordship may say issue notice that interim order in the same terms. That's all. I am agreeing.
We have already passed orders. We have directed this file to be placed before that bench.
All right.
Tomorrow.
All right. That's it. That's it.
Previous matter, I was rushing in the distance.
Interim order. We don't know whether you enjoyed the interim order during the pendency of the matter before the High Court.
Yes, it was there.
37 नंबर अभी शायद बोला गया है, 37 नंबर पे है अभी जो सुनवाई आपका हो रहा है। 37 नंबर सीरियल नंबर का चल रहा है। क्या वीडियो को सिर्फ 65 लोग ही क्वालिफाई वाले देख रहे हैं क्या? ऐसे तो नौकरी मिलेगा 10,709 लोगों को मिलेगा।
I failed to prove I am not in possession. Well, just draw your losses at it.
10,709 में कितने लोग एग्जाम क्वालिफाई किए हैं? जो लोग वीडियो देख रहे हैं, वीडियो को लाइक करेंगे तो मुझे मालूम चल जाएगा कि अभी क्वालिफाई वालों की संख्या कितनी है। 29 अभी 29 का सुनवाई।
The petitioner was the managing trustee. Would my lords kindly see the first election which is being filed?
Rival camp, Nachiket.
Sorry, Lord.
He is the president of the rival camp.
No, my lords, not the president of that. This is there are two camps.
29 नंबर केस की सुनवाई हो रही है। 29 नंबर
For the last 21 years at page 44, page 44. trust. Well, just two factors which are important. One, that at page 44,
जी 37 नहीं
for last
29
the other side wanted to oust me. There was an order. I challenged it. There is a stay order on that operating. Therefore, I continue to be the president. Now, as far as that
appointment.
we have gone now only on that, because I would have otherwise not pressed it. Because two aspects. When he went to the High Court, there is an interim order by the High Court. Because High Court said that you go to the other school and not this school, and therefore he reported there and he continued to work there. And by additional documents, I have now pointed out at A3 Mullahs, he is already appointed in a third school. He is drawing salary. Kindly see Mullahs A3 at my additional documents. Mullahs. Kindly see my application for additional documents. Mullahs. For a moment, Mullahs. Otherwise, I would not have pressed it.
Not a case for me. You know, job को लगा है. This you know, but they are being separate. His value is a bench. He's challenged by you.
I'm sorry, Mullahs. Plus page 12 with this table.
कुंदन कुमार बोल रहे हैं सभी लोग लाइक कर दीजिए और मालूम भी तो चलेगा ना कितने लोग क्वालिफाई हैं.
Saying that he could not have been appointed.
That's right, Mullahs. And in the meantime, while the petition was pending, Mullahs was already appointed.
29 नंबर अभी चल रहा है. आप लोगों का केस अभी नहीं है. अभी 29 नंबर सीरियल नंबर चल रहा है.
Different school from 2023, Mullahs.
The reason why we don't want to share is it's not simply one management. There are contested managements. It is the rival camp. I was appointed him. You are the rival camp.
Now, Mullahs, the most shocking part is the most shocking part is the person who they are seeking to appoint. He's the son. Mullahs, he's the son of the secretary.
Actually, respondent number 8 is not the issue. The issue is the rivalry between your camp and the other camp. That fellow that R8 got appointed by the other camp, and you are unhappy about it.
He's the son, Mullahs. He's the son of that other camp, Mullahs, and therefore my allegation against him. There are financial irregularities alleged against him.
Settle the scores.
No, Mullahs, we would settle Mullahs, but that person is not, Mullahs, he is not the subject category teacher for that, Mullahs. He is teaching history and in Marathi, Mullahs, whereas there is already a teacher available, Mullahs. There is a settled teachers available in the school, and therefore this guy cannot be absorbed. He is also the son of that person, Mullahs. Therefore, there is a clear, Mullahs, apparent this thing that he wants specifically to bring him. Why there are financial irregularities against him, Mullahs? Kindly see my allegations against him at page 134, Mullahs. How could the son be brought by the secretary? I know there is an interim order, Mullahs. Kindly see this interim order passed by the High Court, Mullahs. Why it is in his petition, Mullahs? Mullahs, just see this interim order for a moment.
Not necessary. We are not.
The interim order only indicates, may I just for my satisfaction.
Not necessary.
Just for my satisfaction.
Not necessary.
So the interim order says that he will report to the previous. He's been reporting to that. And from 23, Mullahs, he is working in a third school, Mullahs, which is at an additional document.
Thank you.
Very good.
Item 30.
सीरियल नंबर 30 आ गया 30.
It was item 30, my lord. Sorry. If I may indicate, item 30, my lord, is a matter where there were several accused. The persons who were convicted, my lord, have approached your lordship. Their appeals have been filed, my lord. This is the matter, my lord, where
Why should we interfere in the acquittal, sir?
my lord,
Come to paragraph 415. Yes, 415.
also just giving a
There's nothing, only CDR.
CDR is going to now what the CDR indicates that gentleman, my lord, was there at the time of offense.
What is the evidence about?
The evidence
Tell us.
in so
Come
far
to 415. The A for only PW 16. All of that plan has been PW 16. Is there any identifier?
my lord, so far this case there is concern, my lord, and let me indicate, my lord, what is the evidence against it. It's CDR. I understand, my lord, it's only based on CDR. But my lord, it indicates, my lord, that he was there, he was talking to all the accused persons. He was there at the time of surveillance, he was there at the time of kidnapping.
That's the prosecution case.
My lord, it is proof, my lord. The
No, sir.
CDR indicates, my lord,
One thing.
then, my lord, the CDR indicates he's constantly talking to the other.
That is the only thing. That's the one.
Well, he's been talking to the prime accused, my lord. Only one
doesn't make
8 times, my lord, during this period when he has gone to the place where they took the kidnapped person. He has gone to the place where they killed it.
He went to the place is not. Only
CDR,
sir.
CDR, my lord. The CDR.
No, my lord. This court has consistently held just by CDR you cannot prove a cause.
My lord, yes, my lord. But suppose, my lord, that CDR is talking to all the accused persons, my lord.
Thank you.
Yes. There's a delay, my lord.
फालतू लोगों को लिखने दीजिए, कोई फर्क नहीं पड़ता है, ठीक है ना। एविडेंस है, देखिए मुंह है, कोई भी किसी को कुछ बोल देगा तो थोड़े आप मान लेंगे। अगर किसी के पास एविडेंस नहीं है, ऐसे ही बोलेगा, मुंह है, कोई भी कुछ बोल देगा। वो सबूत है, एविडेंस है, अगर एविडेंस दे देगा तो मैं पूरा जो नहीं बोलेगा वो कर दूंगा। ऐसे मुंह है, कुछ भी बोल देगा, ऐसे तो हम भी बोल देंगे कि उसकी बीवी किसी के साथ भाग गई तो उसको भी बुरा लगेगा। एविडेंस के साथ कुछ बोलो तो अच्छा लगेगा।
Civil matter arranged national commission. He is not agreed. He is the separate urgent matter.
Finding is he has not done anything. His operation was necessary. It was done properly. This is everything.
The allegation is against the anesthesia.
Anesthesia. That too,
Litigation. What has happened? What has happened? Charge sheet has been filed. There is the opinion of an independent medical officer or the CMOH that the conduct of this person is.
जितना मैंने समर्थन दिया है ना क्वालिफाई का, उतना किसी ने अभी तक नहीं दिया होगा। सब लोग घुमा फिरा कर बातें करते हैं पक्षपात वाली कभी, लेकिन मैं एक ही स्टैंड पे रहा, एग्जाम का ओनली समर्थन दिया। और करना भी चाहिए, क्योंकि सभी को मालूम है सरकारी नौकरी का कितना महत्व है आज के जनरेशन में। एक चपरासी का एग्ज़ाम क्वालिफाई करना कितना मुश्किल होता है, सभी को मालूम है। जो तैयारी करते होंगे ना, उनसे बेहतर कोई नहीं जानता होगा कि एक कंपटीशन क्वालिफाई करना कितना महत्व हो गया आज के जनरेशन में। कोई वैल्यू नहीं है, आप कितना भी विद्वान क्यों नहीं है, आप एग्ज़ाम क्वालिफाई नहीं करेंगे, आप सक्सेस नहीं हैं, तो आपके पढ़ाई का, विद्वता का कोई महत्व नहीं रहता है। इतना बात याद रखिएगा। अगर आप लोग तो एग्ज़ाम क्वालिफाई हैं, एग्ज़ाम क्वालिफाई हैं।
Under 498A in a complaint filed in 2007, I move an application for exemption from surrendering. I say that I have only one kidney. I'm suffering from kidney issues. He's about 68 years of age, thrown out of his job. My lord, now 71. Notice, my lord, stay in the meantime. Otherwise, I have to surrender. Exemption, I just said exemption from surrender.
What stay?
मैं उतना खुशबू सिन्हा भैया, मैं किसी के बातों को उतना सीरियस नहीं लेता हूँ। वैसे भी उन्होंने बार बार बोल रहे थे तो मैंने बोल दिया। मुंह है, कोई भी कुछ भी बोल सकता है। आप लोग एग्ज़ाम पास हैं, नौकरी मिलना भी चाहिए, जायज़ बात है। आप लोग के परीक्षा में अनियमितता तो नहीं पाई गई है कि इसको कोई रद्द कर देगा। रही बात नियमावली की, तो 2017 नियम का भी सुप्रीम कोर्ट ने ही जीत दिया है, लेकिन उसमें फ्रेशर और संविदा दोनों को नियुक्ति दिया है। अभी हाल ही में सबका ज्वाइनिंग हो गया है, पॉलिटेक्निक वाला, ITI वाले सबका हो गया है, सिर्फ बीटेक वाले का भी नहीं हुआ है। सबसे जीता जागता उदाहरण है। देखिए, केस जीता जा सकता है। 30 नंबर खत्म हो गया, 33 है, सीरियल नंबर 33 है। अभी आप लोग देखे होंगे कि सुप्रीम कोर्ट के माननीय जाने माने एडवोकेट कपिल सिब्बल, वक्फ कानून के बारे में आप लोग जानते होंगे, जो आज़ादी के पहले भूमि मिला था, उसको लेकर कपिल सिब्बल ने कितना आसानी से केस को तोड़ मरोड़ कर रखा। केस कोई बदलाव नहीं हुआ उसमें। तो जितने अच्छे एडवोकेट उतना अच्छा निर्णय, क्योंकि जज तो अंधा होता है, उसके सामने एडवोकेट जैसा प्रस्ताव रखता है, उसको सुनकर जज निर्णय देता है।
The Chandrama Singh, who was the have got the plots in their name. Now my
5 ओवर मिला होगा 32 नंबर वाले को
my lords got 1, not 2, but 3. Now that really cannot
किसी
be
दूसरे
said that the plots
कोर्ट
have
में
been
सुनवाई हो रहा होगा, इसलिए 5 ओवर मिला होगा, इसलिए 32 नंबर छूट गया।
Millards, no plots are vacant, Millards, and even on merits, Millards are satisfied, Millards. Not.
Now, my lords, I have pictures of the vacant plots. My lords, I have photographs of the vacant plots. Now, my lords, I simply request my lords to consider that if they allot the plots to themselves, now that cannot be said to be that the plots have been allotted to the members.
Be done in a different way, not through this. Thank you.
So, my lords, the monies that have been taken in my account, what happens to that then? Refunded, that's not been to the order.
If not refunded, to ensure it is refunded matter.
My lords, I have not received it till now, and it has to be then returned back with interest because these monies were taken way back in 1983 from me. My lords, 84.
भाई सुप्रीम कोर्ट ने 2 ऑर्डर दिया है, बहुत लोगों को मालूम नहीं है। एक बीटीएससी जेई का बार बार लोग रट लगाता है बीटीएससी जेई, लेकिन एक बीटीएससी इंस्ट्रक्टर डिग्री डिप्लोमा का भी तो सुप्रीम कोर्ट ने जजमेंट दिया है, वो बहुत लोगों को नहीं मालूम है। सेम इसी तरह का केस है वो भी, बीटीएससी इंस्ट्रक्टर जिसमें पॉलिटेक्निक आईटीआई बीटेक वाले फॉर्म भरे थे।
Where the family, the member has more than one plot. The founder member has one plot.
ये महिला है, गिरी सर कहाँ से आपको दिख रही हैं? सूरज भैया, ये बातों से मालूम चाहिए ये महिला है, वी गिरी थोड़े हैं।
This case has been argued before my lords about a disabled child and a father who was looking after the disabled child who had gone to court saying that he ought not to be transferred to Jammu and Kashmir, having regard to the fact that he was the guardian of the child.
32 नंबर है काजल कुमारी, और आपका डॉक्यूमेंट वेरिफिकेशन हो गया है, तो जाहिर सी बात है आपने उस क्राइटेरिया को पूरा कर लिया है। डॉक्यूमेंट वेरिफिकेशन हुआ है तो फिर आपको कौन रोक लगाएगा?
Clarification in the order. Even this IAB.
If your lordship recollects,
देखिए सुप्रीम कोर्ट में हार और जीत का लड़ाई नहीं है, यहाँ पर आज हम बता रहे हैं न्याय और अन्याय का लड़ाई है।
occasionally he can
न्याय मिलना चाहिए।
Kashmir to perform his duties. If I may just read below the last paragraph of the High Court of India.
ये अर्जुन कुमार अम्बेडकर कौन है? तुमको कुछ मालूम है? आपसे तो कुछ ज्यादा ही जानते होंगे।
Please see the last page.
You filed an MA.
Yes, my lord, because I'll explain why. If you just see the last page of the order, my lord, the issue, my lord, it just feels the order reads as if I made a concession, my lord. I meaning Indira Jaising, I made the concession. My lord, all that I considered is what the High Court records. If you may kindly turn to page 9 of the impugned order, I'm sorry, of the original order.
Yes.
This was my concession. This, my lord, if your lordship turns to page 9, the impugned judgment, have your lordship got the original pleadings with you?
What do you want today?
Have your lordship got the impugned judgment, my lord, the original SLP?
But whatever, tell us what is it that you want in the
Yes,
MA?
sir. I'll read it. I will read it. It says that the question arises that the absence of the petitioner would deprive the child of the environment he enjoyed in equal measure with others. Considering the age and the other factors, it cannot be said that his wife would be able to adequately maintain the child. If any of the rights of the disabled child are denied by his absence, going by Section 5, Chapter 2 of the Act, the transfer order passed without adverting to the rights of the child becomes illegal. Now, below, you come to the last paragraph. Paragraph 12. The balancing factors for administration and interest.
You are arguing this.
No, I'm not. Please stay with me for 1 second. Will have the primary done by the organization after adverting to all the circumstances of the matter, including medical reports of the child, the living environment, community life, etc. It is for the organization to balance the administrative needs and needs of the employee. Then, your lordship turns to the next paragraph. The petitioner said before this court that he may not have any objection. Please see this concession. This concession. this concession at para 13. Just have a look. Maybe different.
जो लोग बोल रहे हैं कि फिर से बहाली निकलेगा उसमें मेरा हो जाएगा, तो 28 अप्रैल का एएनएम का रेलवे में परीक्षा है, रेलवे वाला, ठीक है ना। अगर इतना विश्वास है तो उस एग्जाम को भी क्वालिफाई कर लीजिए। बहुत लोग ने फॉर्म भर रखा है ना रेलवे वाला, जो 28 अप्रैल को पेपर भरा हुआ है।
Please see page 17. I made no such concession.
No, madam, we are not inclined to entertain this.
Well, not just you bear with me for a minute. Disciplinary proceedings have been started against him. I wish to make a categorical statement that it has been put in my mouth that I made a concession.
Those disciplinary proceedings are illegal and improper. You have the this IA is not maintainable. File a review.
Just bear with me. I will, if I need to file a review, I will. But the reason I filed an MA and not a review is because these words have been put in the accounts. If it was an order of the court, it would be a different matter for review. It is not. Lord, your lordship just said that I made this concession. And if your lordship turns to paragraph, I made no such concession. It's a different matter that somebody is willing to submit to the order of the court. From page 10 or paragraph 10 onwards. Apart from the legal contention.
नवीन वर्मा, अगर मुझे मेरे बारे में जानना है मैंने एक भी परीक्षा पास किया है या नहीं, आ जाना, ठीक है, एड्रेस भी बताते हैं। बोरिंग रोड आ जाना, गली नंबर 4 के पास, ठीक है। जो मंदिर है ना वहां पर पहुंच कर करना, सारा रिकॉर्ड दिखा देंगे, कितना परीक्षा पास किए हैं कितना नहीं किया, सारा मार्कशीट भी है, दिखा देंगे। भाई पहले जाकर अपनी वाइफ को बोलो परीक्षा पास करने के लिए, ठीक है। नवीन वर्मा, पहले वाइफ को जाकर बोलो कि वो परीक्षा पास करे, क्वालिफाई करे, ठीक है। कितना एग्जाम पास करवाए हो, कितना किए हो, वो दिख रहा है तुम्हारे भाषा से। लिखना बहुत आसान है, किसी के बारे में बोलना बहुत आसान होता है दोस्त, ठीक है। अभी 33 ही चल रहा है।
It's not our decision. This IA is not maintainable. Mr. Bob, this IA dismissed as not maintainable. We also clarified that our decision is not based on the statement recorded by us in paragraph number 11. Satisfied?
Yes, Lord. I cannot.
By your review, then we'll see.
Lord, just say, Lord, surely, if it's a judgment, it cannot be a concession by me. Because I have got to oppose it.
You've recorded that. Justify your review.
Yes, Lord. Your Lordship may just say liberty to file a review.
You said that.
Right. Lord, just one small request, if it pleases with my Lord, just I will certainly advise you file a review.
अरे नवीन वर्मा भाई, जाकर देखो ना अपनी बीबी को, ऐसा ना हो कि कोई लेकर भाग जाए। यहाँ काहे ना ज्यादा टाइम पास कर रहे हो, घर में देखो, कहीं ऐसा ना हो कि तुमको ड्रम में बंद कर दे। ड्रम वाला कहानी सुने हो ना? हम तो अभी कमारे हैं, ठीक है भाई, बच कर रखना। जाओ पहले देखो कहाँ है कहाँ नहीं।
This is coming post notice.
35 नंबर आ गया, 35।
To serve to the central agency.
35।
This is leave granted.
Vice assessment.
Yes, sir, this should be on 4th of June.
Understand, sir? He grant here. Is he here to send it to assessment? Why is it that central agency you are not able to serve?
I'm so sorry, Lord. Well, we, sir, nobody has paid. Yes, sir.
Natraj was here. Natraj was here. Just tell Mr. Natraj that that we have asked you to serve a copy on him. Serve it and come back. Just Friday. The copy of the special petition may be served, maybe sent to the office of Mr. Natraj. But already tell him. We'll not ask you to serve it on, but ask him to appear on Friday. Take a list on Friday.
This is a close measure. Value C measure is 94. I was handcuffed from a 30 days, inflated, kept in the prison for 13 months, 13 days, for an incident which has not happened. There is no complaint or department. And there is a finding by the inquiry committee member. No such incident.
Finally, FIR for this.
36 at 36.
But anyway, what else to be done now that we yes.
I know the false affidavit was filed regarding the incident. False affidavit was made. False complaint was brought on record as per the RTI reply. Can you see page 218? My RTI reply. There is no record of that.
The third round, 8
218. This is a reply to my RTI application.
Contest that. Thank you. You're not entertaining this.
And my lord, when you see the notes was issued page 162. Notes was issued to my application under 340-195. Same was not decided.
Thank you.
Page 162, my lord, can you see?
Sorry, you're not entertaining.
I don't hear request to remand back this matter for deciding that application.
It's still pending.
No, that's not pending, my lord. Can you see the review document, my lord? Can you see page number 2? Page number 2, my lord, the review document. That no reply was filed. This was not decided, my lord.
Thank you. Next.
Item 27, case my lords, I appear for the respondent's state, my lords. May I just make a submission which I think most of the petitioners will not have any objection to, my lords. My lords, this SLP emanates from a recruitment process for professors, assistant professors, associate professors. High Court has set it aside. However, by virtue of an interim order of the High Court, 21 professors came to be appointed in 2017. They are continuing based upon an assurance made by the state recorded in my lord's order of 4823, my lords. My lords, now the state as a one-time policy, one-time measure, my lords, we have taken your instruction and saying we have taken the decision to continue only those persons who were appointed in 2017-18 and have been continuing by virtue of our concession made before my lords. My lords, subject to my lords' approval. There are also certain petitions, my lords, which have gotten tagged along for persons who have no vested right in our humble submission because the recruitment process quit and never completed, my lords. It was set aside by the Honorable High Court. Therefore, there are two sets of matters, my lords. For those who were appointed and working, my lords, as a one-time measure subject to my lords' approval, they can be continued. And for the others,
What do you say? Very fair. So then what you do is you just file a small note or an affidavit
Lordship.
indicating
My lords, I have handed over a note to that effect, but we will file an affidavit, my lords.
file an affidavit.
Please.
You are appearing on behalf of the state.
State, my lords. State.
The affidavit shall be filed indicating the stand taken by the state with respect to continuing the petition. In continuation of 1 minute, Mr. Niranjan, when he appeared,
Yes, my lords.
4th of August 2023, he made a statement.
Only those persons. That's not the others.
In continuation of our order dated 4th August 2023, we direct the state government to file an affidavit. Is this matter of 2 weeks?
2 days.
Any date dispose it of.
There are certain other matters also in which professors were not appointed.
Which item?
Item number 37.6. That is also there is.
Same order, you'll see on that date.
Yes.
My lords, the last occasion, my lords, there was a query which had fallen from my lords. The issue was whether about the period before the date of sanction as aided post. Sanction of aid on that post. So the issue was basically, my lords, whether the state government, by making a rule in exercise of powers under 309, can supersede or prevail over the UGC regulations. So my lords had asked two queries. First is, what independent right do I have for claiming the benefits of senior and selection scale? And secondly, whether the UGC regulations prevail or the state government. Both these two questions. This rule position must be clear. The rule 5.4 is meant. They shall be allowed to benefit of ACP and CSS allowed to their employees state the period from the date of their appointment on the sanctioned and aided post will be continued for the purpose of grant. So he must be appointed, sanctioned and aided post. So the post you hold prior to that is not recognized. No, it is sanctioned, my lords. That's what I'm not aided. Sanctioned and aided. It is only unaided. That is what I'm saying. Obviously, outside UGC regulations under which I was being given this benefit, it does not provide that post has to be aided. But at least under this you won't get. Sorry? At least under 5.4 you won't get. So, my lords, my own whole submission is that Rule 5.4 cannot supersede the UGC rules, UGC guidelines. This is a central 5.4 is made under 309 of 309 directly by the state. So, and UGC is a statute under which a regulation is made. My lords, so the issue is basically whether the state government in exercise of powers under 309 can supersede or add or tinker with the UGC regulations which have been formulated by the UGC in exercise of powers under section 26 of the UGC Act and which has been placed before the Parliament. There are several judgments of this honorable court, my lord. Okay, that larger question is unnecessary. You have raised your case only on the basis of the interpretation of the rule and Prem Prakash Rohit. So, my lord, we are just Rohit case. What does Prem Prakash Rohit case? In Prem Prakash Rohit case, the validity of Rule 5 in general came to be assayed. Now, my lords, but my lords, this issue was never challenged. This issue was never raised. So there are continuous judgments of this honorable court that where the argument was never raised nor considered, then the judgment will not be a binding precedent. It is sub-silent show. This, my lords, may kindly see the entire judgment. There is not even a whisper with regard to CAS. There is not even a Prem Prakash Rohit's case. That is not. That has never been your case at all. My lord, this has been my case. The entire case is this. The judge, the Honorable High Court has also discussed this. My lord, may kindly see the impugned order. The Honorable High Court says that mainly because of the fact that I have raised this argument again. What do you say about that? My lord, his case is that 5.4 is unconstitutional. But till the time 5.4 is there, it's very clear. Tell us about the so far as UGC is concerned, what do you say? No, my rules are directly under, but there are two things. Yes, ma'am. That when was it sanctioned? 98. The Act he joined those services. Sanctioned is on 98. My lords, 98 is on 98. The post was sanctioned in 93 itself. It started getting in. My lord, 93. Yes, my lord. 93 is appointment. Yes, so it was appointed. I was appointed on a duly sanctioned post. That is what I am submitting. My lord, may kindly see the post has been created under the Act of 1989 and the rules of 1993. We will hear you. My lord, so great. So give me. Just a minute. This case is that the post was aided in points. Yes. 1 minute. So far as his claim on the basis of the state's the 309 rule is concerned, to that extent, yes, that's against him. But he's saying over and above that, UGC will prevail. But this, unless you say UGC has no application. My lord, if UGC applies, then in which case the direct judgment is saying that under 309, state is not bound by the regulation made by UGC, which is a statute. Under a statute, the statutory body is making a regulation. Here, my rules are coming directly under 309 of the Constitution. So I am bound to follow those. And my lord, there is a judge. I'll just provide copies of the judge. There is a document. Financial capacity of this.
39 नंबर आ गया है, 39।
Limited to only return of the advance consideration. This morning, the defendant has filed an affidavit saying he's agreeable to that. So the order can be passed, except that matters may also make some provision for interest. He's had the money now since 2011.
There is that order of number 39. First April.
First April 2024. There is a slight error in the order. It says respondent's landlord. He was not the landlord, he was the owner of the.
First April, okay. First April 24. Page I. We granted the return of advance. We granted the special invitation. Yes, sure. This special invitation is against the judgment and order passed by the High Court.
39 नंबर है विजय कुमार जी, 39 नंबर। यूके ऑफिशियल चैनल 2023। बस कुछ क्षणों बाद आप लोगों को मालूम चल जाएगा कि केस का सिचुएशन स्टेजेस क्या है, क्या होने वाला है, सब आंखों देखा हाल आपको मालूम चल जाएगा। उम्मीद तो है कि फाइनल हो जाना चाहिए आज केस। ये आज केस फाइनल हो जाएगा तो बहुत अच्छा रहेगा, क्योंकि आने वाली बहाली जो है उसको लेकर लोग अच्छा से तैयारी करेंगे। एनएम का जो सुनवाई है 42 नंबर पे है, ठीक है, 39 नंबर चल ही रहा है, तो 40 दो केस के बाद आपका हियरिंग होने वाला है, ठीक है, 2 केस के बाद आपका हियरिंग होने वाला है, तो बस अब आ ही गया है। 39 के बाद 40, 41, उसके बाद 42।
The error in the first order.
That is what's that?
But it says that return of the advance paid by the petitioner to the respondent's landlord. He's not the landlord.
Respondent owner. Right? Owners.
He's actually not even the owner. He was the power of attorney holder.
Respondent to
Respondent.
I'm going to say it. Here for injunction specific. Appeal for reverse it. Lodging is a will come. Lodging given 6 weeks.
Until the date
6 weeks amount will be paid within 6 weeks. April.
And that's interest to the date of payment.
Till the date of payment. Yes, we have already set date of payment. From 34/2015 till the date of payment.
Actually, the next time something will pass over. First 2 weeks time for filing different documents, let cover anything.
Also for both the parties, the special invitation. So let's start after vacation.
सुजीत कुमार वर्मा, थैंक यू भैया।
Next.
I'm seeking accommodation for a week, your lordship.
लंच हो गया।
My lords, I'm appearing for respondent number 126 in this matter.
Necessary party. You are ready? Still, I think we will not go on here. So what time is this?
अभी लग रहा है सुनवाई होगा,
Next month, your lordship.
हो जाना चाहिए, 1-2 ही हेयरिंग पर है।
Then
क्वालिफाई का टीम पहुंचा है कि नहीं? एडवोकेट लोग तो पहचान में भी नहीं आ रहा है कौन कौन है। अभी लंच नहीं हुआ है, सुनवाई चल रहा है। चालीस नंबर चल रहा है। हिमांशी मल्होत्रा.
that I want to fill up the post of 10,000 by way of written competitive examination. The respondents who are the writ petitioners, they are asking their demand.
हो जाएगा आप लोग का सुनवाई. एक के बाद तो ही है 42 नंबर.
Yes, yes, sir. There is one small change. Yes, yes. When there's urgency, so there's just one small point. What is urgency? So there's urgency generally. Clear it. Fine. Wednesday we will take it up. Yes. Very well. Very well. Very well. Very well.
Petition also lordships have issued notice that I will last Thursday.
You also go down your Wednesday. The petition is still happening. It was given a because we will only decide on the vacation. You want
Yes, yes, yes.
लंच 1 बजे के बाद ही होता है. 1:30 बजे होता है, 2:30 बजे आता है, खुलता है.
Dates to somebody. As far as the reply is concerned, not reply far from the reading line. It's a question of law only. I will rely upon the affidavit. As far as concerned, it negates the standard state. That's our solution. What do you want, sir? So just Wednesday week instead of this Wednesday. We'll file a short note of Wednesday.
As far as the report is,
Just give a date.
very good. Just give time. In writ petitions, we have already served the standing counsel.
इसके बाद आप ही लोगों का सुनवाई है. लंच नहीं होता है तो सुनवाई हो जाएगा.
We'll await the outcome, but because some writ petitions have been filed, but we'll file ours also. Very well. Very good.
This I think writs may have to be heard first. I mean, that's what I feel. But I didn't recall it. It's not got the next occasion. It will overlap.
लग रहा है लंच हो गया क्या? नहीं है.
Substantial statute for retirement expense.
I know coverage by the other party, but there's something I wish to point out. There's something in there. 39 issued notice. Lordship issued notice on the application SLP as well as application of condemnation of delay. I don't think there is any delay, my lord, in the SLP. It's a mistake. No, there's a refiling. There was some delay. Refiling 8 days, my lord. I don't come in this. So this is also to be considered.
Tell us what is it?
No. My lord, in this case, this is ultimately now we were the plaintiff in the court below.
Yes.
This was judgment of
What a
reversal.
declaration that the
Judgment of reversal before the only one. Now, if the order in question is same, because now if the order in question is same, my lord, because on the first day
इसके पीछे अमन लेखी सर थे ना, संविदा के भी एडवोकेट. इसके पहले वाले जो हियरिंग हो रहा था वो अमन लेखी सर ही थे शायद. सुनवाई हो गया, कुछ मालूम भी नहीं चला. 30 सेकेंड भी नहीं लगा. कि अभी तो ये बोल रहे हैं कि 39.
Referee, now for a moment I will take now 2 minutes of the honorable Joe.
we will admit the case. You are telling us some kind of a question of law. What arises?
So now the first question of law is, now there was no pre-existing right with the defendant. There could not have been now relinquishment in favor of the defendant itself. This was because relinquishment is for enlargement of the interest, not for creating any right interest itself. Now this was taken up by the court below without my lord finding on this regard. This starting from
आज आज आप लोग का केस फाइनल नहीं हुआ। आप लोगों का केस फाइनल भी नहीं हुआ दोस्तों, ठीक है। क्या चल रहा है मालूम भी नहीं चल रहा। 30 सेकेंड भी नहीं लगा।
Look at page 1. Judgment was reserved. They were heard. It was reserved. And to say today will not cast aspersions on the High Court that the first day itself the case has been passed. That doesn't matter. We are not impressed by that. We are not impressed by that. Granted. And my lord, I will pray that some short let us go make an implementation. I am running a resource so to preserve this property.
आखिर ये केस में चल क्या रहा है समझ में नहीं आ रहा है। बहस और सब केसेस इतना अच्छा से बहस हो रहा है और एनएम के केस में शुद्ध से 1 मिनट बहस भी नहीं हो रहा है।
This side of the vacation should not. Otherwise, this is a litigation which we are fighting in 2008. That we succeeded. Two courts were not succeeded.
You don't need to join issue on everything.
I succeeded. Last of that, secondary court I have succeeded. But how am I wrong?
गजब हो रहा है, समझ में नहीं आ रहा है ये केस कब फाइनल होगा। डेट पे डेट मिलेगा तो सब लोग पागल हो जाएंगे और इसी में सब कोई पेराएगा, सब कोई परेशान होगा। जितने यूट्यूबर हैं, जितने यूट्यूबर भाई लोग और जितने क्वालिफाई लोग हैं, सभी देखिए, सभी यूट्यूबर भी और सभी कैंडिडेट भी लोग चाह रहे हैं कि केस क्लियर हो जाए, लेकिन लीडर लोग ना क्या कर दिया है क्या बताया जाए। इतना बड़ा एडवोकेट रख रहा है लोग डेट लेने के लिए।
Get barred by limitation. Why not pass the order? Then the limitation would get extended.
Where is your application, boss?
Yes.
चलिए, मुबारक हो आप लोगों को, फिर से एक नया डेट मिल गया। केस कई लोग उम्मीद जताए थे कि आज क्लियर हो जाएगा, लेकिन आपको डेट मिल गया, फिर से एक नया डेट मिल गया। अगले मंगलवार को या बुधवार को अपना आपका सुनवाई होगा फिर से। एक केस अब देखिए कब तक चलता है। अप्रैल में तो अब क्लियर नहीं होगा, अब समझ लीजिए। 10 लोग बोल रहे हैं कि 10 लाख रुपया दिया गया श्याम दीवान को, तो कुछ और मिलाकर कपिल सिब्बल को क्यों नहीं रख लिया लोग। 10 लाख रुपया एक हेयरिंग पे आप बर्बाद कर रहे हैं डेट लेने के लिए, फिर क्या फायदा। और दीजिए आप लोग फंडिंग, डेट लेने के लिए 10 लाख रुपया कलेक्शन कीजिए और 10 लाख कलेक्शन कर लीजिए लोग। अगले डेट पे फिर एक डेट ले लीजिएगा लोग। फाइनल ही नहीं हो रहा है। सब केस में इतना अच्छा से रिप्रेजेंट एडवोकेट लोग कर रहा है। खुद आप देख रहे हैं साक्ष्य। कोई भी केस अभी तक आपने देखा, 1 से लेकर सीरियल नंबर 44-45 तक, सारे केसेस में लगभग 2 मिनट 3 मिनट 4 मिनट बहस हो रहे हैं, बात चल रहा है। और खासकर यहाँ पर बिहार सरकार डिले कर रहा है। जानते हैं बिहार सरकार भी इसमें टांग अड़ाने लगा है अब, क्योंकि बीपीएससी केस में देखिएगा, बीपीएससी उसमें भी उससे मांगा गया था एफिडेविट, तो वो भी आनाकानी कर रहा था। उसको बोल रहे थे कि हमको कुछ मालूम ही नहीं है, तो वो तो सीनियर एडवोकेट रखा गया था कि उसके वजह से वो घिरा गया लोग, नहीं तो उसमें भी पिरा जाता लोग। कल बीपीएससी का भी सुनवाई है देखिएगा, और कल ही हो सकता है कि फाइनल हो जाएगा। 20 सेकेंड 25 सेकेंड बहस हो रहा है आपके केस में। आप खुद आकलन कर सकते हैं, अंदाजा लगा सकते हैं कि 20 सेकेंड 25 सेकेंड केस की सुनवाई पर क्या कोई कंक्लूजन निकालेगा। नेक्स्ट डेट पे हम प्रेजेंट होंगे, नेक्स्ट डेट हमको दे दिया जाए, नेक्स्ट डेट। बताइए, ऐसा सुनवाई होगा तो केस तो ये पेंडिंग पड़ा रह जाएगा, क्लियर ही नहीं होगा।
She has not taken admission.
Not taken admission now. Matter explained.
Things are right.
I'm seeing
डेट
for a
के लिए
pass
10
over.
लाख रुपया दे रहा है लोग। आप लोगों का भी तो गलती है ना।
Or I'm
हैं?
hearing from the
कुछ नहीं
counsel.
हुआ जी, पूजा कुमारी, क्या होगा? सब कोई डेट पे डेट।
Pass over.
अच्छा, सीरियल नंबर जो 61 है उस पर भी एएनएम का सुनवाई है। एसएलपीए नंबर जो है या केस नंबर या डायरी नंबर उसे चेक करके देख सकते हैं 61 नंबर पे। अभी तो 48 सुनवाई चल रहा है। पास ओवर लिया है तो पास ओवर लेने का मतलब ये हुआ कि एक ही समय में 2 कोर्ट में सुनवाई होगा। पास ओवर का मतलब ये होता है। हाँ, कल मैंने एक वीडियो बनाया था इस पे कि श्याम दीवान का ज्यादातर केस रहता है एक ही समय में 2 कोर्ट में पड़ जाता है, जिसके वजह से पास ओवर के लिए वो बोले थे पहले ही। नहीं, क्वालिफाई का एडवोकेट है, ठीक है, क्वालिफाई का एडवोकेट है।
Not paid, right? That has no justice. He is not paid. I can extend.
65 61 के 65 कौन कमेंट किया है? 65 पर एएनएम का सुनवाई है।
So see, now you are coming. You are interested so much, right? Now you are. SLP discussion.
Consider this aspect, there is a school running, the students are
Not you did misuse of SLP discussion.
when we grant us some time to comply with the order, the school is running, there is a school which is running.
नया डेट के लिए बोला गया है, डेट मिला है आज, डेट एक्सटेंड हो गया है फिर से। थोड़ी देर में अपडेट होगा, ऑफिशियल वेबसाइट पर आप देख सकते हैं, चेक कर लीजिएगा। 25 सेकंड सुनवाई हुआ है आज के बहस में। पास ओवर के लिए बोला गया है। अप्रैल महीने में तो आप लोग का सुनवाई अब उम्मीद कमी है, समझ लीजिए। अपडेट होगा कुछ देर में तो मालूम चल जाएगा आप लोगों को। मई का इंतजार कीजिए लोग। 10 मई को एसएलपीए, 10 मई को समझ लीजिए कि सुप्रीम कोर्ट में एसएलपीए दर्ज हुआ था। डेट मिला है, ठीक है ना। नेक्स्ट डेट को एक्सटेंड कर लिया गया है, डेट एक्सटेंड हुआ है।
Representation may be considered under such time. No,
we think that there is a lot of issues in this.
Students are studying, my lords.
No.
Until such time of representation,
We have granted enough indulgence. Thank you, SLP.
lords, until the time of representation.
All right, don't repeat.
देखिए, लंच तक अगर हो जाता है तो ठीक है, अगर लंच नहीं हुआ तो इंतजार कीजिए लोग।
Because I have retired, so the question of considering me for promotion does not arise.
नहीं, हमको बताया गया है, कल बताया था लोग कि पास ओवर लेने के लिए तो
No department takes 9 initiative.
How long will you take it?
Now let me point this. In 2013, I issued a notice. They went to the High Court. They filed a
23 मई को सुनवाई है।
Is there a stay of this?
अभी तो ऑफिशियल वेबसाइट पे नहीं दिखा रहे, हम चेक कर रहे हैं, तो अपडेट हो जाएगा तो मालूम चलेगा।
They didn't produce the caste certificate. Unless the caste certificate is produced, we can't do anything about it.
Unfair.
My lords will appreciate, here is a person.
Very, very unfair.
My lords,
Most man's complete life is gone.
my lords, can I just
2013 till today, nothing happened.
Can I point just 2 things and then I think my lords will agree with me in this particular case.
Go back.
My lord, she comes under a caste reservation. Her father, who works in a public sector, his caste certificate is produced. Belight says he has never declared himself as a reserved category. Notice is issued to her because the appointment is done under a reserved category to produce a caste certificate. Here are 2 letters of my lords, just 1 minute, that's it. She approaches the High Court. That petition remains pending. In the meantime, she files 2 petitions when the promotions have to happen to say she should be given promotion.
In the interregnum, the High Court directs that she should produce the caste certificate. She fails to produce the caste certificate, now takes advantage of the fact that she has retired. And my lords, all throughout from 2013 is my notice to her. If an employee manages to do that for a period of 10 years, what can I do?
To consider this.
Has always been in dispute. Now the company cannot be, because it's a public sector, she does not produce her caste certificate. She cannot take advantage of both the things, that she should be given those back promotions and she retires on those.
Madam, that decision is to be taken by you in the first place. That has not been taken. Then the question of giving her retirement
It is because she never produced her document.
that is exactly what we are telling you. You are actually agitating an issue which is not arisen.
But my notices got challenged in the High Court. What do I do?
Thank you.
My notice to produce the certificate
All right.
challenged in the High Court.
Next step, please.
Then overreach.
52. Yes.
So this is a short.
High Court has yes.
And we want to close the matter. If your lordship has a look at the at section 12A, that's the only little problem. We should just have a look at section 12A. I believe we
guarantee a
got more copies available for the court.
The NCLAT's decision is confined only to that shorter issue as to covered by Baiju, I think. What is
that's right. So I'll just explain it in this situation. Let's have a look at the language of section 12A.
What are you suggesting?
What I am suggesting is that in the peculiar facts of the present case, when the people who are resisting filing an application for settlement are themselves in conflict, which I will explain to you, obviously the inherent power applies. There is an inherent power under Rule 11 for the purposes of doing justice in an appropriate case. So Baijus correctly says that look, you have to follow the drill under 12A, but it can't be, but it reserves obviously an open certain situations which can't be anticipated. This being one of them.
Section 11 applicants itself. Just
Rule 11. Sorry.
No, confine only those who have initiated the process.
So that is 12A. Just see 12A. Just see 12A as it stands. We've given the
Section
12 capital A. Then I'll give you a few facts. Rule will be 11, right?
No, 12A. Section 12A, right?
Your Lordship, sorry.
12A, withdrawal of the application at which
Correct. So I'll place it. Withdrawal of application under section 7, 9 or 10. The adjudicating authority may allow the withdrawal of the application admitted under section 7 or section 9 or section 10 on an application made by the applicant with the approval of 90% voting share of the committee of creditors in the manner as may be specified. Correct? Now let me give you a little background.
Here, section 7 was at the instance of the assistant director.
Now, so let me tell you what the trick over here is. So this is the problem. Therefore, we say that there is Rule 11 which I have handed over separately, which you may just have a look
Not
at.
the commonality like either a creditor or a operation.
This is a direct conflict. I'll just explain to you what has happened.
You have a point there.
Yeah, so the erstwhile director has put in a resolution plan. So he doesn't want this settlement to take place. I am borrowing money today under the settlements because I have settled with the entire COC, 92.17%. They are accepting the consent. They have either got terms or they've issued a letter which we have placed on record.
You are the revival director.
I am the current, I'm the management which came into the picture in absolutely the people. In 2017, I've been running this hospital. It's a 150-bed hospital at Pimpri Chinchwad. So what happened essentially was that the old management exited. They exited.
By section 7.
They thereafter filed a section 7. In that section 7, the matter progressed as it has, but we've got 92.17%. I am servicing those agreements because I've already got settlement agreements. I'm borrowing and paying those people out. So this hospital has to be revived. Now I can just show you a couple of documents over here as to why. So have you also seen Rule 11?
Yes, Karen, there is a contest here, I suppose.
Well, they don't dispute 92.17%.
What do you say?
I appear on behalf of the respond number 612. Of them, 3 were the
Original applicant.
Of them, 3 were the original applicants. 3. But thereafter, they submitted their forms before the IR. Now, the matter as it stands today is that, firstly, so far as 92.17% is concerned, that's not correct. Punjab Bank, who owns 24% voting share, has merely given a letter. So what letter is
What stage is the CIRP? What stage, Shams?
It is just so the states to adjust it. Now, may I just answer that question with reference to 509? Just have a look at page 509. So to answer the question in brief, they have put in also an application for revival, the erstwhile directors. So they are conflicting because they don't want this settlement to proceed because they want to try and take the hospital back on the cheap. Now the High Court, because there was a certain element of fraud, etc., and preferential payment, the NCLAT has remitted the matter back and state proceedings until those applications are considered. But we are saying that those applications can continue separately. Today, the settlement must be taken on board and the matter settled and the item closed because nobody disputes 92.17%. So that's the end of the matter. We placed all the documents on record with the secured creditors, written consent in this regard.
This arises out of the application that you filed before the NCLAT.
Yes.
NCLT.
Yes.
Taking the close the CIRP proceedings by virtue of
the settlement is the peculiar facts. Ordinarily, 12-way drill has to be followed.
They have the jurisdiction to do that. They have held that your IA is not maintainable at all.
That's right. You're right. But when our court also decided by Jews, they realized that 12-way is the ordinary process. But that doesn't mean that in peculiar circumstances, inherent power can't be exercised. This is a typical case for inherent power. And the reason becomes clear from 509, page 509.
A few dates. I'd like to make sure.
The cat is out of the bag. He doesn't want to settle. How can a party say?
What you're saying, even if we accept you, we need to interpret the provision.
Yes, you will have to reconcile that.
There are a few more things.
You'll have to interpret it.
My lord, firstly, I have
granted an interim order to you.
My lord, there was always stay on this.
Just now, there is the NCLAT itself has stayed for the process. But it has found that its hands were tied. I don't believe so. That's why we will
have implications.
Sorry?
Interpretation.
Yes. I hear you. Yes. Yes.
Okay, tell us.
So, my lords, there was the original admission order, my lords, as a chief finality. The right judgment is very clear. If there is a specific provision, there is no need to exercise powers under Rule 11. It's very clear. So, in fact, let me add this. There was an application 1238 that they filed for the NCL.
No, the only thing is that it's a difficult proposition that he has advanced. But then if there are instances where the position is absolutely clear, but does one have to go to the entire drill altogether?
But he's not raising. Why is he withholding consent?
There is something.
Why is he withholding consent?
I have never been approached for a settlement. This is an unusual case. All the other cases in the past, the original applicant has been approached. I have never been approached. It has happened.
90+%.
Not behind my back. It has happened behind back because she was sent together.
Look, so if he just let me be very clear. Let me be very clear. Let me just indicate straight. it is possible to sit together, but it's not possible to arrive at a final settlement because he's entered into circular transactions when he was in management, etc., and siphoned off the money. So that's why the fraud allegation, which is
Can we refer the issue between you two of getting into the legalese
yeah.
for some kind of a mediation?
So all right, so I will accept that, but may I request, it's a very short point. If your lordship keeps it, if not this week, next week, we'll put in a written note because
I'm asking you that to be prima facie, that's a
that has to be reconciled.
if the courts have said that instead of invoking that jurisdiction and let the NCLT look into the matter and then see to what extent it is to be done in the entire CIRP process itself. To put some kind of a short circuit to it as you are suggesting.
No, I'm not making it.
It's a different matter. But in the meanwhile, if there's a possibility of both of you settling it, we'll postpone it for some time, or else we'll hear and discuss it. Yes, or even here.
Yes, it's the issue. I'm this thing, but my own personal sense is that I've had the advantage of some discussions. It's not a large figure at all. I mean, even the figures which are but unfortunately, the situation seems to be that it's
how much is the money?
So I got sorry. Correct.
Maybe a little more. I need to check. Not a big amount. We will ask somebody to conduct the mediation. Both of you are agreeable. We'll do it right away. Yes, my lord, there is an issue. Start working.
देख लीजिए सब अब खुलकर एक बात बता रहे हैं कि आप लोगों के टीम का और फिर जो विपक्ष रेस्पोंडेंट वाले हैं सब एक दूसरे से मिले हुए हैं, ठीक है, और ये इतना जल्दी क्लियर नहीं होने वाला है जब तक आप लोगों का एक एक खून का पूरा चिहुट नहीं जाएगा, पूरा खून नहीं चूस जाएगा लोग, तब तक ये समझ लीजिए बहाली कैंसिल नहीं होगा, ये क्लियर नहीं होगा, समझ लीजिए। आप लोगों का केस का सुनवाई आज में भी हो जाए, नहीं होगा, ठीक है ना, तो थोड़ी देर के लिए पास ओवर की बात बोली गई, तो उसके बाद देख लीजिए अब इस केस के लिए इनके पास समय है, लेकिन उस केस के लिए भी वो चाहते तो बोल सकते थे, उसी समय बहस कर सकते थे।
Yes. In the meanwhile, we'll refer it.
I think that's a fair option. And please require us to remain present this week.
In the meanwhile, we refer
my party accommodation in the month of May. In the month of May, I'm unavailable. If you're given 4 weeks, anytime after 27th of May, then it will. What's the matter? We heard it the next week. I'm okay. I'm between 4th of May and 27th. I'm not available. I'm okay.
We can't force a mediation on it.
May I just suggest?
So that's why I said your lordship say on 27th of May.
If you're sorry, yeah, whatever. If he's your lordship on what day?
On 27th of May.
Not 27th, next week.
Next week, I'm okay.
No, my lord. So what we do is we try and sit down. Your lordship may keep it on next Wednesday.
Not a date. Or not, you won't take 27th. If we don't settle the matter,
You want not after 27th.
not before 27th. You want a date before 27th.
May. No, don't take our time. By deciding the case, we'll proceed together. The dates will be announced. Yeah. You give us, both of you agree, and then give us the dates. We'll fix it up on that date.
Yes,
Whatever.
you just give it.
Whatever, you give it to the court.
We just give it to the I'm ready. We'll put it Tuesday.
Whatever you.
We'll try and sort it.
Last order of first scheduled my notes.
देखिए ये है अमन लेखी सर।
4 months. My notes give a limited notice of 4 months my notes extension of time to vacate. I filed an undertaking my notes yesterday.
He is agreeable to vacate.
नहीं अमन लेखी सर नहीं है, ये है वो क्या नाम था इनका, अभी याद नहीं आ रहा है।
Brother.
Real brother is my notes. Since
Real brother.
the other side is my notes persuaded by able friend. My notes, he can be sorted.
You are equally able, Mr. Bala.
Yeah, yes, my notes. It will be sorted out actually, my notes. If it can.
We give it you vacate, then it can be sorted out. Yes, Bala, what is it?
This
Visitation.
First of April.
Performance that was dismissed, he has agreed to vacate within what time?
4 months as Lordship has given, I don't want to say.
We are not inclined to interfere with the order passed by the High Court. The
Undertaking has been filed. Copy bit.
Just undertaking you undertook to vacate him.
Vacate in 4 months as per Lord's direct.
Date.
First date, first of April, 4 months. 31st of July.
Undertaking has been filed to vacate and hand over peaceful possession within a period of
4 months.
4 months.
From 1st of April to 1st of April. I have given undertaking.
These directions, especially to the statutes. Thank you.
From like 30 years off.
I have not yet. I did the fact.
चलिए नेक्स्ट डेट पे मिलेंगे दोस्तों, ठीक है। एक केस आप लोग का क्लियर नहीं हुआ। डेट विल बी एक्सटेंडेड, ठीक है।
Respondents have been served. Please grant the support time to serve on this.
List after service is complete.
Yes.
Next.
Also, after correspondent number 1, I will receive instruction.
55 नंबर सुनवाई हो गया, ठीक है। और मिलेंगे नेक्स्ट डेट पे। फिर जैसा अपडेट होता है, अपडेट लेकर ऑफिशियल वेबसाइट पे अपडेट वगैरह हो रहा है तो उसको देखकर एक फ्रेश वीडियो बना देंगे, ठीक है। ये क्या क्या हुआ, क्या क्या बातें बोला गया दोस्तों।
56. What's the position now?
They demolished it very same as the morning.
But we are all very quite unhappy about the dates.
Can I give those laws again to
Order passed by, we got the report from the High Court also, we have seen it.